Talk shoes. Recorded live.
All right, welcome everybody to our regularly scheduled Wednesday night talk shoe call, Just American, and we are discussing NTT, New Trust Technology, which is making payments under trust and merging titles and extinguishing debts. My name is Matthew. Thank you for joining us. We have special guest Christian Walters on the show with us tonight, and Christian is going to go right into a Q&A session. But before we start, we're going to read the Notice Acknowledgement Agreement. This show enter document is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making the legal decision or for performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show enter documents are for academic informational purposes only to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show and or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in authorized capacity as liaison to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and show recordings are completely void of this notice agreement being attached herein by reference and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for ad penalty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. And with that said, we're going to go ahead and jump right into Q&A, folks. So first come, first serve. Hit *8 on your phone. It'll show up on my screen, and we'll get an opportunity to ask Christian a question. And we'll be kind of playing touch and go here, assuming Christian still has connectivity. All right, Christian, I am going to officially turn it over to you. You have the floor.
Okay. Thank you, Matt. How am I coming in?
You sound great. And our first caller is Mike. Mike, you've been unmuted.
How are you, Matt? How are you, Chris?
Thanks for the call.
Good. How are you?
All right. Mike in Chicago here. Christian, I got this book you recommended, Florida and Federal Evidence Rules, with commentary.
Yes.
At last someone picked it up, right? I've got two questions, one general and another one a little bit specific. General question about this book is there area which I can omit or not to pay too much attention when I will be reading? You know, I'm kind of constraining time, so I just want to hear from you. Is there some areas which are more important and others less in this book?
Yeah, the area really we want to focus in on is, let's see if I pull it up here, 90.506 and 507.
This is about the privileges, if I remember this.
Yes. Now, 90.506 is privilege with respect to trade secrets.
Mm-hmm.
And then the next one, 90.507, that's a waiver of privilege by voluntary disclosure.
Okay.
And those two sections there are probably say the most important ones there. But there's different sections in there that you know make reference to different things and would straighten some things up that people have some misconceptions on.
Okay. I will attempt to read it all, but you know, I've got issues which I want to take care of, so I might not be able to read it all. But another specific.
But one other thing was let's see, back in the back where it's talking about Federal Rule 1003, Federal Rule 1003 and Florida Statute 90.53 or 90.953. And it talks about admissibility of duplicates.
Mm-hmm.
And I found that was very knowledgeable there to find out that, you know, duplicates could be submitted unless you made objections. Duplicates would serve as originals.
So you're referring to the fact that so many people in foreclosure attempt to get original promissory note, and courts very often accept just copies.
Yeah, unless you object.
Yeah, actually, I don't know if I will be able to find interesting. I got it. Interesting thing in regards to what we just talked about from another book you recommend, Popular Law Library. Equity, Jurisprudence, Trust, Equity, and Pleading, by Albert Putney, whatever you can. I'm not sure how to pronounce it. What Putney? This book is from 1908. Are you there?
Yeah. There's a lot of good books on the internet there that are free for going over equity. So.
Yeah, I look at this book, and I haven't read this book whole, but I look at section 46, lost instruments, and it was very interesting when I was reading it because it clearly states that equity can accept the copies of the contracts, and if I can read excerpts from it. I got in front of me.
Sure, go ahead.
Section 46, lost instruments. One of the most important class of accidents against which equity will grant relief is found in the case of lost instruments. Relief in such cases can in some instances now be obtained at law, but the relief in equity is older and more complete, and this is 1908. Mm-hmm. Another excerpt. I've got just two small ones. It is an old and familiar rule that although the holder of bill, I go back to another one. Equitable relief of this character extends both to the case of deeds and to unsealed instruments as bill and notes. Could be promissory note, right?
Yes.
And there is another one, just quickly. It would be against conscience that the maker should escape payment of an honest debt. So that's for me. I mean, when we go to the court and ask for original wet ink signature instrument, equity doesn't really care. If there was debt, it has to be paid, even if the original instrument is lost. That's what I'm reading out of it.
Yes. Uh-huh.
So that was kind of interesting find for me.
So that gives you a way to challenge first off, that there is no debt. Now you got to prove that there is a debt.
Yeah. You better not
without the note.
You better not to go as a debtor and hope that just because there is no original of your debt that you can escape from the debt. You
right.
have to come as a perhaps beneficiary, but never debtor.
Other circumstances, yes.
Right. Okay.
Relationship. Yeah.
Let me go to this Florida and federal, and I've got another question. Hypothetical. Okay. If I would petition the court, let's say tax court, which is federal, and I would want to introduce the evidence, and let's say it would be evidence of post office receipt, let's say certified receipt, and I will know that regulations IRS regulations would have to treat this receipt as prima facie evidence, okay? When in this book I can learn how to introduce such evidence in the federal court?
Well, we were talking a little about that last night with, I believe, Darren, and we discussed that really in the case, most people don't present any evidence into the evidence file, even though they may have prima facie evidence attached to their pleadings. So nobody moves any evidence into their evidence file, and when the judge makes a ruling, he looks at the evidence file and there's nothing in it. So if there's nothing in it by either party, usually the prima facie case by the plaintiff usually wins. So we don't know how to get evidence in. We don't know how to create records.
Yeah, that's why I got this book.
So you really want to get, you attach your copies of what you got, which makes you a prima facie case, but then you got to get the originals entered into evidence in an in-camera hearing or at an evidentiary hearing. And that's what an in-camera hearing is, evidentiary hearing. And that's where your material facts on the substantive side of the case.
I'm sorry, I didn't explain myself very clearly. In the case of tax court, I'm talking on the at-law side. I did some research on the tax court, and they claim there is no equity in the tax court. So in this hypothetical situation, everything must be on the at-law side. So I know it's we're talking about trust and entity, and I've been on this call for six months now, so I know everything about it. But this particular issue is kind of my obsession. Let's put it this way. That's why I want to talk about how to introduce this really at law side. And
yeah, well, even the same situation applies to the evidence file is barren on the at-law side. We don't move any evidence. We don't have any evidentiary hearing to move evidence into the evidence file.
So to understand how to do this, I have to look for information about evidence file and evidence hearing.
Well, the evidence file is like an invisible file that the judge has. It's probably in the same folder of your case, but it's like he's got a divider in there or something that lets him know, or a paper clip holding it together or something, and that's really the evidence file. And until you move it from one side of the case into the evidence file, there's nothing in the evidence file.
Okay. And where is this book I can read about it? Do you recall?
Well, that's one of those unwritten rules here. I think that, you just file something in the case and file it with the clerk, and that's putting it into the case file, into the evidence file. No, it's not. You have to have an evidentiary hearing and present your evidence at an evidentiary hearing and move it into evidence.
Okay. All right. So
you have to have a motion to move such and such a document into evidence at a evidentiary hearing, and then you have to have a notice of a hearing, a notice of evidentiary hearing.
Okay. So probably I will have to look in Article 4 relevancy and its limits, and this is about relevant evidence. So I have to look in this.
Yeah. A friend of mine was in a case, a federal case, criminal case really, and they said, you're going to lose because we know how to get evidence in and you don't. And we know how to keep yours out.
So even if I might feel good with the fact that I've got in this hypothetical situation, that I've got prima facie evidence, and in theory, burden of proof will be on the other side. If I will introduce this correctly into the evidence, that means nothing, simply. It's not prima facie evidence because I didn't really follow the...
Yes, because if they have the greater weight of evidence, that and usually the plaintiff is favored anyway.
In the tax court, taxpayers are petitioners, so they are plaintiffs, and automatically burden of proof is on them, right? But if the plaintiff will have prima facie evidence, that switches burden of proof. okay, unless evidence is not properly introduced.
Right, right. Now, what they'll do is they'll try to keep your evidence out by objecting, and you'll have to understand the evidence rules because you want business records, you want self-authenticating documents that can't be objected to under the hearsay rules. So you want to make everything that you have comport to some kind of document that gets right into evidence without an objection.
Mm-hmm. Okay.
So, and then you got to keep their evidence out by knowing what they're trying to introduce and object to it also on the same grounds, that it could be hearsay, it's unsupported, it has no foundation, it's not a business record, but so the evidence rules is pretty important if you're going to be playing on the ad law side of the case. In fact, even if you had an equity case and getting into chambers.
Okay. So you think that this book will help me to understand how all this...
Yeah, because it's not as simple as everybody thinks. All I have to do is attach a copy of something to the complaint and file it with the clerk. That's not evidence. That's prima facie evidence, but it's just a copy. Just like when they're coming at you with copies, you want them to produce the originals. Well, you got to do the same thing. So you want to produce the originals in court, in open court, at an evidentiary hearing. Get it on in the evidence file. So what do they do with you? They present you with a copy of the note, but you didn't object to the copy, so the copy stood as being an original, duplicate, and they could come in and submit that, and they ask you if that's your signature, and then you say yes, and then they put it into evidence right there in open hearing. And then you authenticated it right on the spot.
Yeah, I was puzzled. I've read federal court case, where judge give their opinion about the defendant who claimed he don't remember if he put the signature, but the judge was stating that he could take a defense of saying this is not my signature, and that would be right way to approach it, but the defendant never brought this up. And I think this is a decent objection when you have a copy and you say this is not my signature.
Yes, and also with a signature on a promissory note, you have to go to Article 3 in UCC, and I forget which number it is. I think it's 206 in the footnotes. It says in there, unless you specifically object in the pleading to the signature, then later on you waive it. You can't object to it.
Yeah, but there's lots of nuances to learn.
Yeah, little tricks that people learn the hard way on. So,
unless we learn equity, and I want to bring another just interesting point from what I've read about the loss to instrument. I mean, this last sentence I read. It would be against conscience that the maker should escape payment of an honest debt. And that shows what you've been saying so long. It doesn't really matter if the evidence exists. The heart of the matter matters in equity. I mean, was there that?
All the other issues are secondary.
Yeah. I mean, Christian, like I said, I've been listening to you 6 months, okay? And you inspired me to go through the whole library. I had in my hands CJS, American Jurisprudence, Illinois Practice and Law books, and I did some research on tax and tax court, and so many, even small things I can find in the print, which really confirms what you've been saying, like the fact that the courts must obey, let's put it this way, comport to the IRS record. I found it. I mean, I don't have to, I rely on what you're saying, but I'm finding confirmations of what you've been saying in their books. Let's put it this way. So
that's great. That's great. It's out there. It's just people have to find it, and when you find it, then it just it starts making sense more and more. but there's little nuggets of sand, golden nuggets of sand. You got to pick them up where you can find them and put them all together.
Christian, I think I found one nugget of gold, I think, which was not discussed here. And I think the thing I have, it's in my belief, can bring more efficiency in the court for us entity practitioners. But that's my opinion. I would like to have an opportunity to introduce you to this information, which I believe you won't be unfamiliar with, but I feel like you didn't take another look at this information after you discover NTT. And I'm talking about objection to personal jurisdiction. Okay? I don't know if you want me to talk about it.
Yeah, you can. Go ahead.
Okay. In my research of tax court, I picked up this small book, Civil Procedure, from written by law professor, and it's from Wes Thompson in a Nutshell series. It's just a snapshot of civil procedures in U.S. courts, and I found, and this one sentence, actually 3 sentences, really got me going to do more research. And I tell you, it clicked with me because I kept in mind what you've been saying, to pay special attention to some specific words. Let me read it to you. This is about personal. This is about personal jurisdiction. Actually, about objection to personal jurisdiction. One method of challenging the court's personal jurisdiction is by special appearance. Many states require a defendant who wish to object to personal jurisdiction to enter a special appearance prior to answering on the merits. In order to preserve this objection, the defendant typically is not permitted to introduce any other defenses at that time or prior to making the special appearance. If the defendant does so, he will be deemed to have made a general appearance and to have waived the right to object to jurisdiction. And when I've read this, I noticed special appearance and general appearance and commingling. Okay, and that caught my interest. I thought, is special appearance a special deposit in the court?
Yes.
Right. Now, I've been on this information for 2 months now. I researched it more. And I've heard so many times that people kind of mentioning special appearance in opposition to general appearance, but I realized that they don't really know what I know about special appearance. Okay? And this really, I wanted to research it, but I couldn't connect appearance, the word appearance, with the word deposit. So I kind of been thinking about it, and I researched the word appear, what the meanings of it, and among many other meanings are appear means come into sight, or become visible or noticeable, or come into existence. And then I realized that by act of our by the act of depositing our person in the realm of the court, our person appears in the court. It wasn't into existence, into a court, until we deposited it. And this is our choice. If we want to deposit it specially and understand really what it means and follow the procedure they created for us, and they did.
Yes. Yes.
Or
except we have one problem though.
Okay.
It's already been deposited generally. So we have to correct the general deposit already done and withdraw it and redeposit it special.
I realize that. Okay. when I'm talking about special appearance, I understand it has to be from the beginning of what we're gonna do with the court once we've been sued. And you probably agree with me that in this transitional phase of NTT, we are sued. We are sued, and really we should be plaintiffs in equity if we express the trust properly and either see repudiation, which is just absolutely unbelievable subject I want to talk to you about someday, or breach of trust. But we're in transitional phase of NTT now, so we're either in the court or will be soon in the court, and probably many of the people will be coming to these calls will be sued because they sued because the claim was filed against them. And I think understanding the special appearance might help them to go right from the beginning. And I see the path we might take. But let me answer your argument here. One of the things I did in the research of special appearance, I went to.
Hi, Kathy. Hey, it's Matthew calling back. Hey, I was able to talk to Lori Dahlstrom and explain the situation, and she's more than happy to have you bring your PC by in the morning after your doctor's appointment to have her take a look at it.
Hey, Matt, you're on the open call.
Sorry, Christian.
I went to American Jurisprudence, second edition, 1996, under appearance. There are not that much about appearance, but let me read you just titles of 4 paragraphs. They are in American Jurisprudence. Paragraph 1 is titled Definition, which is just usual. Paragraph number 2 is called General or Special, understandable. Paragraph number 3 is abolition of distinction. And I've heard opinion that special appearance was abolished or eliminated. And let me read it again. Abolition of distinction. They abolished the distinction. Then they eliminated the differences. They hid it.
Yes, right.
And they did it 10 years ago.
So let's say they hit it, instead of being special appearance now, it's now pleading special matters. Under trial.
Actually, they hide it by motions, Christian, not by pleading. And I really did research on this. In federal and in some states which follow them, with Illinois too, okay, they hide it by motions. So there is a specific way of filing the motions, or rather specific motions as well as behaving in court to appear specially. Okay? So if we follow it, we will be in special appearance. But interesting, going to the point you mentioned, paragraph number 4, it's called withdrawal of appearance. And I discovered this right after the call of when Chris brought this withdrawal thing. So it really, we got general or appearance, special appearance, and withdrawal of appearance. I mean, you've been talking about deposits, special and general, and withdrawal of deposits for months, right? So that's really struck the accord. But you know what? I went to CJS, and if you go to CJS under appearance, you will find general appearance, special appearance, withdrawal of appearance, and you also will find very small paragraph about reappearance. So what we're having here, in my humble opinion, okay, not only way, but I would think our preferable way to deposit our person into the realm is by following the procedure of appearance. Now, I've got more research on this. I've got more research, and I can really talk about it for a long time. But the problem with this might be also that if we appear, okay, we're objecting to jurisdiction, which might be a good thing. Judge has to decide if judge has the jurisdiction over us, and if he decides that he does, we've got our objection. So we got appealable objection, okay? So it might be interesting for him to see if we will claim in the chambers that we got a trust, how he will eventually decide that he's got objection over this matter. Actually, it's personal jurisdiction, not subject matter jurisdiction, and here I'm kind of murky, but I see how from entity point, the proper way is to appear specially and follow the procedure. And actually, I designed a model which I would be following based on the information which I did not have a time yet to introduce to you. And
you have to overcome their fact that they say that the special appearance has been abolished, so or abrogated, or whatever you want to call it.
But it wasn't abolished. They abolished the distinction, the differences, how it looks for the eye not prepared to see it.
Yeah, okay? We'd have to be prepared to defend that, because they'll probably make an objection to that and say, well, that rule that's been abolished or repealed or whatever.
You know what? When I was researching it, I met in this library the lawyer, and he knew everything about special appearance. I didn't talk to him too long, but he knew.
You could get around that, though. You could get around that by saying that was a mistake, and then proving a mistake is a special pleading, special matters, and then coming with the evidence to prove it was a mistake, because you've got your withdrawal and your redeposit. And you got that evidence to back it up as a mistake of the mistaken appearance as general.
Right. Okay. Okay. I'm not saying I got all the answers, and there might be holes in what I'm saying, but in my research, but I've seen some interest.
Trust. Trust is giving them something that they can see. And since trust lives in equity already, then they've got like a viable entity, so to speak, that is an equitable entity, and they can't really dispute that.
Okay, Christian, I hear you. I understand what you're saying, but I don't want to be argumentative with you. You're the grandmaster of NTT, absolutely. So I'm not trying to argue with you, but I want to give you the...
I'm just saying, I've tried special appearance before, and I know what happens, that, they tend to poo-poo it and say, oh, well, so... Yeah,
but there was also, like on Saturday, this gentleman on Skype who appeared specially, and he had his... he appeared specially verbally, actually, but he had this bill of equity, and that kind of not the way I would do, but it seems like judge recognized that special appearance still exists. And
yes,
it's valid.
At one time it's probably still there. It's hidden in equity, like everything else, like common law and the Republic and America. It's there.
Okay. Can I read you one more thing, which really was important for me, okay? Perhaps you will see something interesting in it too. That's from Illinois Law and Practice. The paragraph saying what constitutes general appearance. Any affirmative attempt to make use of the protection of Illinois law constitutes a general appearance. That's understandable. As in any attempt to make an argument on the merits of the action, that's true. Further, a general appearance is made by, and here are the examples, Christian, a motion to dismiss, and I would say naked motion to dismiss, because if you couple with other motions, it's a special appearance. But that's not the point. A general appearance is made by a motion to dismiss, a motion for change of venue, it's general appearance, and further, a pleading, answer, or counterclaim. Okay? And like I said, I don't want to be argumentative about it, but it confuses judge. Okay? We're pleading, and we want to appear specially. We're counterclaiming, and we want to appear specially. I mean, that's not special appearance, according to him. And I'm not saying he can bend, but he might be resistant because it's not proper at law procedure. Because, Christian, I believe if there is no adequate remedy at law, the only thing should happen is dismissal. Nothing else, because this is not the place. If we go to court because we've been sued to court at law site, what we need is dismissal. What we need really to be plaintiff in equity, and you know that you can go into separate action with bill of equity and swallow this at law procedure, because there is one maximum of equity, which will kind of mention this opportunity. But what I see is, whatever we do at law, we need dismissal. We don't want to be there any second longer than we need to, and even if we proceed, we just go with separate action on bill of equity, and that's basically the shortest version I have for you. What do you think about it?
That's kind of like what I was saying, to not claim an at-law remedy and just do equitable pleading, and therefore you bypass the at-law side. You go directly to equity. Okay, but we can. But for me, more proper way I would think is just go with separate action, because if we're pleading or counterclaiming in this at law, in most jurisdictions it will be general appearance, and we want to be in special appearance, which is direct. Counterclaim is equity, so if you have a counterclaim, that kind of puts you in the equity right off the bat, and then if you put the equitable switches in there and don't claim any adequate at-law side remedies, just do the equitable maxims and things. Yeah, I thought I'd bring you for consideration, and I know there was no reasons to look into special and general appearance before NTT, because I know I've researched. Nobody talks about personal jurisdiction. Everybody talks about subject matter jurisdiction. So I know that this Patriots movement before NTT never considered this as a opportunity to do anything with it. But if we understand special and general, and special deposit and general deposit, and see special appearance and general appearance, there must be something in it. So that's my point. That's why I brought this up. Yeah, and anything with special in it, whatever it is for the private dam. If it wouldn't be for the fact that they have, say, abrogated or repealed it, then and they say that it doesn't exist anymore, then that might be someplace I wouldn't want to go. No, they clearly say. I read the Supreme Court annotated about it, and they don't say it doesn't exist. No. Yeah, it does exist, but what has happened is it's been put in trust, just along with everything else. It's still there, but it's been put in trust. It's on the other side of the court. It's in the equitable side. All right. Okay. But that's the whole thing of the focus of NTT. How do we get into a court of equity? Until we discovered, we don't want to claim any more at-law remedies. If we don't, then there's no adequate remedy in law, and it's got to be an equitable claim. Yeah, I agree. I think you're 100% right. There is no adequate remedy at all. I'm just thinking that this might. I thought that I want to bring some more understanding what special appearance is, because I've heard that people using this term and even using general appearance, but they, in my opinion, not using this properly. Okay, but they might not have been. Years ago, that was pretty popular, coming in a special special appearance. That was the whole game plan, special appearance.
Mm-hmm.
But just like everything else, it didn't really work. So.
Okay. I don't think it's going to work. I'm just thinking this is our way to really jump into the deep dark water with some.
The reason why I don't think it worked was because the trust came along and everything that was in America got held into trust. Then it's still there being hidden, although it exists there, but it exists in equity.
Mm-hmm. Mm-hmm.
And the trust, if you use the trust methodology, trust live in equity. So that's one vehicle to come in, a trust vehicle, NTT, and just get right into equity using the trust.
But you agree generally with me that we should be plaintiffs more often than defendants. If we
yes, plaintiffs instead of defendants. Defendants always lose.
Yeah, and basically we got a case if we express trust and create the evidence the way you've been teaching us for almost a year. Then the only way we could be in court when we will be plaintiffs basically, and they either breach of trust, the breach of our trust, or they attempted to repudiate, and we want to defend it.
Right.
So that's the reasons why we should be in court. But now we're in transitional phase with many of us, even TAs, have these court issues, and they wanna really do something at law side too.
Yeah, but what you had ties in with what we've been doing with redeposit. So on the Depp Swart package that we're working on, that would close the case down before it even really gets started. So.
Mm-hmm. Mm-hmm. Yeah. All right. Christian, I can tell you that you changed my life. You give me hope, and I've been for a very long time on your calls, and I would say I got 300 hours, and I'm not counting them because I started to listen to old calls from November, and at some point I started to listen current calls because I thought I had enough, ground laid down for understanding what's on new calls, and I can tell you I enjoy your conversation with Eric more than anything else, which probably 6 months ago I would not understood, not even the bits, but it's coming all together.
Yeah, you're living proof that it takes a while to get up to speed, and it just can't happen overnight, and there's no fine wine before it's time.
Absolutely. That's what I want to say. And unfortunately, there is no shortcut.
There is no shortcut. There is no shortcut. You got to put the hours in. If you don't put the hours in, you get no relief.
Yeah, I hope that's encouraged some people. Okay. I appreciate you give me your time, Christian. And I'll be back probably with more discussion about repudiation. I'm kind of surprised that it was never followed up properly because with this repudiation thing, I mean, more understanding came to me than anything with anything else. But I still have to review this information. I've read everything from the source you've read, and I need to have another reading, and then eventually I want to run some scenarios for you with you to understand more about it because I think it's crucial.
The repudiation, that's what they're doing all the time when they send you the offers in the mailbox or in the court, whatever it is. It's all repudiation.
Yeah, and basically, I wanna understand more about adverse claim and imputation because I think that's kind of crucial, and I wanna do this in a simple way. And but I have to review it again, not to ask you. I wanna argue with you a little bit. Not that you just be ignorant what conversation is all about.
Yeah. All right.
Thank you.
Okay.
I'm done. Thank you.
All right. Thanks, Mike.
Thanks, Mike. Folks, if you got a question, go ahead and hit star 8 on your phone. We don't have any callers standing in line at this point, so here's an opportunity to ask Christian a question. If you got any questions out there tonight? Just hit *8, folks. Here we go. We got a caller with a question. You've been unmuted. Go ahead with the question.
Hey, Christian. This is Donna Lee, Florida.
Hi, Donna.
How are you doing tonight?
All right.
Oh, good. I was just trying to find some different CEOs' names, addresses, etc. And it seems like it's getting really, really difficult. Like they know what's going on, and it's like I tried to get the current CEO's name of Greenpoint Lending, or let's see, Greenpoint Mortgage Funding, Inc., and also for U.S. Bank National Association. And I talked to both of those different banks, and basically what they said was, they don't give out the CEO's address, but they would be more than happy to give me a P.O. box number. And I'm like, wait a minute, I'm trying to send registered mail. So,
well, don't you just send it to the CEO at the? Actually, it's probably with the Secretary of State that you check with, because they all have to be registered in the state they're doing business in, and that registration, they have to state who is the address or who is the receiver of documents in case there'd be a legal action. And that's probably the person that you'd probably have to send it to.
Oh, to their registered agent.
Yes. So it'd be the CEO, whoever he is, and then probably have to send it to, say, the registered agent.
You know what?
I think usually the registered agent is the CEO.
Here's a problem though, because I checked into that, and I'm trying to remember where I found that. I think maybe the judge was telling me about that, where they are, if they are this all came out with the Mears thing, where Mears was trying to, go after, they were trying to foreclose in their own name, and Mears was not, let's see, I believe it was foreign businesses
right.
Don't have to be registered within each state. So the banks get by with that. They
have to have a home registration someplace where their corporation was incorporated. They have to have a home base. They have to have a registered agent, because if they created a corporate entity, they have to have somebody that's going to be able to do acceptances for a right to be sued. Because if they have a right to sue, they have the right to be sued also, and they have to have a registered agent to go through. And usually that might be an attorney.
So you don't see any problem whatsoever with sending it to the registered agent?
No, because that'll probably get to the guy, the CEO, that,
Okay. And I wanted to ask you one other question. Now, let me give you a hypothetical here. Okay, say I have different businesses that I have created, and one of my companies purchased real estate.
Oh, you're a good slave then.
Yeah. This is hypothetical. And
if you got a business, you're a good slave. Yeah.
Right. Exactly. Because when you incorporate, you're not down as the owner or anything.
Yeah, if you're doing business, you're effectively connected with the United States Business or Trade and taxable.
Right, and they now own the business.
Uh-huh.
So
you're just an agent for the U.S.
Exactly. Okay, so say this hypothetical business that I own purchased property in its name. Would I still be able to use NTT for that? To just say if one of my businesses that I own bought real estate and is now being foreclosed on.
Yeah, you can use NTT for it. Yeah.
Would I go after it in my own name or the business name? I couldn't do it under the business name, could I? That doesn't that wouldn't really make sense. A fiction doing NTT.
Yeah, probably because the fiction couldn't be seen in equity, so it had to be coming at us through the real life man or woman there as the agent for the corporation, say.
Okay. Agent for the corporation.
It's like you got to put the hat of the straw man on and go into the fiction land and appear that way, or if you get into equity, you take the hat off.
Okay, but bring it forth under the name of the corporation?
Well, the equity couldn't see the corporation because you couldn't get it into equity.
Okay, and
through equity.
Also, you know, the real man or the real woman did initiate the fiction to begin with.
Right.
So, okay. So, just the living woman's name.
Yeah, you'd have to appear in court probably as a straw man fiction entity, and then if you get it into equity, then you'd be appearing as the real live woman.
Okay. All right. Wow, I really appreciate it. It's like I really stuck to it, and I go into withdrawals when you're not on, just so you know. I go into absolute withdrawals, and this is Wednesday, so I'm thinking, okay, what am I going to do Thursday and Friday until Saturday rolls around to get in here?
Oh, it's the NTT chat room, yeah.
Yes. Well, we do have that, thank God. But I really appreciate it. I mean, I'm so excited. I am so excited. This is like so exciting. I can't even explain it. You guys are wonderful. I just really appreciate you so much.
If you knew what we were working on, you'd be a whole lot more excited.
Oh, you have to tell me now. See, I need like a red phone, you know, like Batman had with the governor. Please, Steve, I need a red phone to go directly to you and Lisa. Well, now I have to know, so I'm gonna go bug some people. But I really appreciate it so much, and I'll get off the phone so other people can get on.
Okay, all right.
Thank you, Kristen. You have a fantastic night. You too, Lisa. Thanks.
All right, thanks, Donnelly.
Thanks, Donna. Anybody else got a question for Christian? Go ahead and star it on your phone. Well, folks, let's see if we got anybody with a question. Hit star 8 on your phone if you got a question. I see some people just recently logged in here. If you're just getting logged in for the first time, folks, we went right to question and answer period. And so people are asking questions now. There's nobody in line. If you got a question, hit star 8. Here we go. A couple of them popped up here. Next caller, you've been unmuted. Go ahead and give us your first name and where you're calling from, please.
Hello, this is Don from Arkansas.
Hey, Don, welcome to the call.
Hello, how are you?
Good. How are you?
I'm doing fine. Christian, our conversation got cut off last night.
Yeah. We had. Seems like we got a lot of internet problems going on.
Yeah. So I went ahead and sent you a copy of the document that I was reading from, and the part that I wanted to discuss with you was the very last part.
Okay.
Did you have a chance to look at that?
Our internet's been down all day, so.
Oh, so you haven't had a chance to look at it?
No, I haven't.
Well, you weren't able to read, or I guess not hear very clearly last night. If you like, I can reread the.
Let's see. I did get something I went over. What was it? The memorandum?
Yeah.
Okay. Yeah, I did go over that before it went down some.
So my question was related to that. In the CJS, is it saying that, and it wasn't CJS, it was actually the American jurisprudence stating that the lower courts may not have jurisdiction over equity or equitable pleadings. Is that kind of what you got from that, or am I reading that wrong?
Yeah, I know that probably municipalities do not have equitable jurisdiction, but some county courts probably do, and for sure the state courts and the federal do.
Yeah. So just go in and ask for equity, and then if they say there is no equity there, then we have to go on to the higher court.
Well, no, I'd call the court up and ask them, is this wherever the court name is, ask them, is this a court of equity?
Uh-huh. Okay.
And that way, before you can go in there. And if it's not, then you can go in there with a motion and remand it into a court of equity.
Yeah. And take it to a higher court from there?
Yes, get it into a court of equity, because there's no use going into some court that does not have equity.
Right. Well, another issue, we put in a motion for a equitable accounting in one of our cases, and the lawyers wrote back and said that there was no something along the lines that it wasn't necessary to do an equitable accounting in this particular case. Is that for the lawyer to determine?
No, that's a repudiation of the trustee duty.
Uh-huh. So do we need to respond to that? That was a response to our...
yeah, because he's doing the repudiation. If you don't respond to it, now it was your duty to do a response and come back at him and tell him it was his duty as a trustee to do it anyway. Then what you'll be is you'll be imputed with the trusteeship, and you'll be now the trustee.
So if we go back now and reject his repudiation and tell him it's his obligation as the trustee to come forth with all of the accounting of this case.
Yes, this is your opportunity to cure the potential breach here, and give him like 3 days or a week or 14 days to come up with the accounting as deemed.
Yeah. Okay. Well, we
tell him I don't accept your repudiation. You are the trustee. Must do the duty.
Uh-huh. Well, the lawyer came back with another response to the request for information related to the foreclosure, and came back and said that the people who had actually initiated the foreclosing were not the people who were the owner of the note. They were just the servicers of the loan. And yet they were the ones who went in and filed for the foreclosure. Has he not shot himself in the foot?
Yeah, because is that in writing?
Yeah. It's in one of the motions that he put into the case. Or one of his, actually it was a response to our request for all of the information related to where the note went and who all had it.
Well, that's a motion to dismiss based on the failure to join indispensable parties.
Yeah.
Now, the judge will probably grant them, say, 30 days to come and amend the complaint, or else it'll be, say, dismissed with prejudice, maybe.
Mm-hmm. Well, we are the ones who filed the lawsuit against them. It's a non-judicial state, so they were just.
All right, so it's the other way around. All right, well, let's see. Well, here's where you need to do discovery on them based on that evidence and find out who the real parties and interest are.
Yeah. Well, if the real party of interest is not them, and they're the ones that initiated the foreclosure because they said they were, are they not bringing fraud upon the court?
Yes.
Well, he adamantly denied that they were bringing fraud upon the court. That's one of the things he adamantly denied.
Now, that brings in the doctrine of unclean hands, another equitable claim.
Uh-huh.
I don't want to say doctrine of unclean hands. It brings in the unclean hands maxim. Let's put it that way.
Yeah. Yeah.
That DC stuff dies hard.
Well, that case is going to...
That would be a bar to the foreclosure action, because if they admit that they weren't the real party in interest, then they couldn't have foreclosed.
Yeah. Well, that's what we're thinking.
And that would be an admission to their omission, which would be the fraud. Omission is a fraud.
Uh-huh.
So they admitted to their omission. And that would be my counterclaim. Or a new claim.
Uh-huh.
Counterclaim action, or maybe a new claim action against them for this one. Do an amended count. Or do another amendment, a new court action against them on a new claim. You could do that.
Yeah. Well, this case is going to be heard by the judge on the 27th of October. I went in and had asked for some an injunctive or a RTO to be signed, and he said he wasn't going to sign it at that point, but he was going to call a hearing, and he would sign it at the hearing. So I suppose we need to bring all this information out at the hearing?
Yeah, because if you got an omission, an admission of their omission, now that would be grounds for good cause shown for him to grant a temporary restraining order.
Uh-huh.
Or a preliminary injunction.
Yeah. Yeah.
Because that's showing prima facie evidence that their admission that they committed fraud. There's your damage. There's your irreparable harm and damage.
Right. Yeah. They kind of
freeze all their actions on the disposition of the house.
Yeah.
Something I was going to say, but I forgot what it was. This hearing. What's the hearing coming up for?
Oh, it's coming up for these motions that were put in for, the discoveries that we requested, and which they are denying. They haven't come forth, and we asked for the equitable accounting, and he wrote back and said that there was no need for an equitable accounting in this matter. It was irrelevant or something along those lines.
Okay, they cannot block discovery, because you can ask for anything as long as it leads to admissibility of some kind of document.
Right.
And all they're doing is they're just doing a stall tactics. If you keep pressing on that coming in with on a motion to compel hearing, they'll either postpone the hearing, or they'll really can't postpone it. It's your hearing, so they may dismiss, or they may do something, or try to do something, but they can't get into this hearing and have the judge hit them with a motion to compel with an order.
Uh-huh.
If they do, then they're the next step down, sucked down into the funnel a little harder, farther down in, and they got more problems now.
Uh-huh. Well, we kind of think they've got a lot of problems because, this admission that...
Yeah, so if it does happen, if they get the order issued, then they're probably going to have another 30 days to compel, and then if they can't, then, it just gets worse and worse, and the case starts falling apart for them right then.
Mm-hmm. So then at this point, could you come in and ask for treble damages and all that stuff?
Well, I don't know how you're playing a case, but I would go through the equitable side and get the performance.
Oh, okay. Yeah. Well, we are expressing the trust. We've
I want the performance. I want the performance. That's what I want.
Right. Well, we did our claim was that there's a trust here. it's been paid and there's a breach of trust.
Yeah, we're going for an order for them to do the mandatory performance, and then the court remains to have jurisdiction if they don't.
Right.
That way you could come right back into court if they didn't within a certain amount of time and get them for a contempt if they didn't perform.
Right. Now, what about going ahead and putting in the motion for putting them in receivership and having the judge appoint a trustee is that part of the equitable accounting?
Well, if you can't get the performance, and if you'd asked for the trust res back and they didn't give it to you, or they didn't make a payment, you'd want to do the tracing and the maybe the possible receivership.
Mm-hmm. But the receivership thing might be farther down the road.
Yeah, down further, right.
Yeah. Okay. Okay.
That would be like if I asked for a merger and extinguishment of the debt and the case was supposed to be terminated, or the trust terminated. When they didn't do it, then I would suspect that they absconded with trust res and converted it, and that's when I would be asking for a receivership to do the tracing.
Well, we kind of know that's what they've already done, and it's kind of obvious if they sold the note.
Yeah. Everything within steps, you know.
Uh-huh. Well, all right. That's my questions.
That memorandum, do you want to talk about that?
Oh, yeah, if you want to, if you don't mind. I kind of understand, or I understand from feedback from Lisa that it might have contained too much at-law stuff, and I might need to go back and make it a little more specific for equity.
Yeah, because I did a search in there for the term equity, and there's no term in there at all about equity.
Uh-huh. So, yeah. Well, I just went through and cited CJS and cited...
yeah, you made a lot of good points for the Gilbert there.
Yeah. I wanted to bring out the information that we as the grantor have the right to go and correct a trust that's been misconstrued.
Uh-huh.
And a lot of information.
You have access to the restatement on the law of trust on the second?
I have that in my notes to go look that up, but I don't think I have access to it yet.
Yeah, that would probably be the best thing to use that with Gilbert's or say with CGS. The restatement of the law of trust, the second.
Now, is that on the ForShared website as a PDF?
No, and I don't have a full copy of it either, so if anybody out there had access to a digital copy of the second restatement on law and trust, you know, we sure would appreciate that.
Yeah, that would probably get some good information in it.
Yeah, it does, because I was going over the first 16 sections that I got, and right in there, that's some of the stuff you want to put in there.
Uh-huh. What about Google Books? Would we be able to find it there?
I did a search and tried to pick up the other sections, and I didn't see it. But then, you know, don't let that stop you from trying to maybe find another source if I didn't see.
What about the law library? Would we be able to find it there?
Definitely there.
Okay, we'll go look. Is that a like 1,100 page book, or will I be able to photocopy?
It's a three volume set.
Oh. Any particular section I should concentrate on for the purposes of this memorandum that I can photocopy while I'm at the library?
I don't know specific sections, but, you know, the beginning starts defining the definitions, what a trust is, what property is. A lot of good definitions there, setting up the foundation for. And then it completely explains the elements and the necessities for it, and that's the restatement on the law and trust.
Right. Uh-huh. Okay.
Now, I know we really haven't focused a whole lot of time on it, but it's probably the Gilbert's and CJS is probably, resting on top of it.
Uh-huh. Okay. Well, make another trip to the law library.
Yeah, but I would make probably one, the memorandum in two parts, make one for equity and make one for trust.
Oh, okay. Well, I have never written a memorandum, so I wasn't quite sure how to approach it.
Well, equity is just, the 12 or 15 so maximum, so that's not going to be that hard.
Uh-huh. So I could just do an equitable memorandum and cite all of the maxims and put that in as well? Or do I need to elaborate a little more?
Yeah, put the equitable maxims for the equity section.
Okay.
I mean, that is equity. Those 12 maxims.
Right. Yeah, the 12 maxims pretty well stated.
Yeah. We'll get the internet back up. You got to Skype us for. I got a folder here. It's full of trust stuff. Probably help you out on that. A little better than what you've got.
Uh-huh. Well, would appreciate it. Anything you might want to share.
But I've got the complete restatement on the third on the trust, but I don't have the complete restatement on the second law and trust.
Uh-huh.
And Bogart's on trust, you can get that. You get that off the internet. That would help also.
Right.
Because it starts off, it says Section 1, Scope of Restatement. It talks about the matters included. It talks about matters excluded. It talks about the charitable trust, resulting trusts, and right off the bat. And then it gives you all kinds of the case sites that supports that.
Yeah.
On a state-by-state basis, anything that was important. And number 2 is the definition of trust. You give the judge this in a memorandum, and he's almost got to do list the terminology, whether it's private fiduciary relation. It defines that. It gives you different illustrations of property, title, and ownership, and equitable interest, equitable duty.
Uh-huh.
It talks about the manifestation of intention of the trust grantor. It is actually the actual skeleton of the trust. It's the trust law.
Right. So the stuff that came from the Scott's Law on Trust is probably based on all that information then.
Yes. In fact, if you could get the restatement on the first also. I don't have the first, but see, the first came out in 1923 and went to 1935, I believe. They made some major changes then or so. And then 58, I think it was 58. Then the second came from 58 to 85, and then from 85 on is the third.
Uh-huh. So would it be a good idea to quote all three of them, or the most recent one then?
Well, it seems like there's a lot of meat in the second. The third is more made it to more modern times. I don't like that one. But, because if we're changing or claiming venue in 1776 law form, then we probably want, say, pre-33, and that would really be restatement on first.
Yeah. Well, a little bit more homework.
Say again?
I said we have a little bit more homework or research.
Yes, a little more, yes.
Well, very good. I think that's all I had questions about. I have to get off and let somebody else talk.
Yeah, there's so much that we really need. We need some people that works, because if you lay the ground foundation down and get the basics in there and stuff, and then we can start working on it with a basis to come from.
Mm-hmm. Yeah.
And then we can start polishing it up and make improvements on it from there.
Right.
But Skype Lisa, and I'll give her this folder that I got here.
Okay. That'd be great. And I'll continue typing.
Yeah, because it contains Bogart, the law of trust and trustees. I got conveyances of land and declarations of trust, and the three statement of the third, a part of the second, and some stuff on business trust.
Uh-huh. Well, we have a little bit more time before these court hearings. So
yeah, we could get a memorandum started for the trust and one for equity.
Mm-hmm. And isn't it a good idea to go ahead and put the memorandum in each of the cases?
Yeah, because that way you give the judge the law that he set the rule on.
Mm-hmm.
That way they can't say, well, I don't see a trust. So here's what the law says the trust is, and here's what I got in my pleading, and I got what in my pleading, what the restatement says, and now you can't tell me whether or not you don't see a trust.
Right. So you kind of paint them in the corner, as it were.
Yeah. Really, we are in control of the courts.
Yeah.
When somebody says, oh, those darn judges, my antennas go up right away, and I can just bet you 10 to 1 that it's not the judge's problem. It's the guy that goes in there. It's his problem. I ran across a maxim for pro se's. And it really made me laugh because I really understood what it was saying. And it was saying, okay, the number one law for a pro se going into court by himself is to, when you know you're 100% right, know that you're wrong.
Yeah. Very true.
I really find that when the judge says something, he's not against you. He's actually telling you what you're doing wrong, but you're not listening.
Right.
And you need to take 3 steps backward and take a day and meditate on what he said, because the solution to your problem is what he said, because he's really telling you what you need to be doing.
Right. That's the reason it's probably a really good idea to use cases that aren't life-threatening to learn this stuff, go in and make the mistakes. And
people make foolish, stupid, dumb mistakes, not realizing what they're doing, thinking they were 100% right.
Mm-hmm.
And they weren't. They're not.
Yep.
And the judges, they always say, "Do you sure you know what's going on? Do you know what's going on in this court?" What he's really saying is, do you know the procedures, the form, the process, the rules that we go by here? Because this is all a charade.
Right.
It does not function the way you think it's supposed to function.
Well, in our case, sometimes the lawyers on the opposing side will point some of that out when they do the responses. You're not playing by the rules, and you need to go look at this rule and follow it.
Yeah, now we found out we can get it to exclude their rule game, the one they've been hiding all the time, which was equity.
Mm-hmm.
And equity is the way it's supposed to function, but there's two games being played in this court, the one you don't know about, and the one they're trying to get you to play.
Yeah, which they haven't told you what the rules are. Of course, you can always go read them. I have found in reading the Civil Rules of Procedure, it almost seems as if you need to have read the whole book before you can really know, well, which rule applies here and which rule applies over there tomorrow. Is there some way around that other than just reading the whole book, or?
No, it's like UCC. When I read UCC, by the time you get done reading UCC, you finally realize that all UCC was worthless. It just it was telling you in there, unless otherwise by agreement all the time. Unless otherwise by agreement. Unless otherwise by agreement.
Right.
Well, there's the two general deposits and special deposits right in all through UCC. It was special deposit unless otherwise by agreement.
Mm-hmm.
And here you didn't need the whole UCC, but yet you had to read it all through once or study it until you finally came to the realization that you didn't need it.
Right.
It was all by agreement.
A special agreement.
Yeah, special agreement, yeah.
Well, until you get into equity, you have to traverse through the minefield of the codes and regulations or procedures. Now, in our case, where we've made it or stated it up front that this pleading is in equity, does that give you any kind of a bypass of all of that procedural stuff, or are you still having to get through the procedures?
Well, no, you should be able to bypass a lot of the rules, process, and procedures and stuff by getting into equity.
Mm-hmm.
That way you don't have to fool around with the statutes and codes and the 63 million statutes and codes they got. You bypassed all that, and you went directly into equity where only there's 12 maxims.
Right. Well, it's obvious that in some of the pleadings that we got responses from the lawyers, they don't recognize any of that, and they claim, well, you're trying to pay with monopoly money, and the lawyer had some other.
Yeah, they can't recognize it because they're fictions.
Yeah.
It's an equitable asset, and fictions can't see that.
Yeah.
They never will.
They can't even respond to your motions that you put in inequity, your counterclaim, what have you.
Can't respond to an equitable counterclaim or equitable. Equity is nothing to do with that law.
Uh-huh. Well, was the lawyer attempting to do that when he said that a equitable accounting of this matter was not necessary or warranted? I think he used the word warranted.
Yes, right. So he's trying to, what the DC people would call recontract you, but really he's doing a repudiation of the trust.
Uh-huh. Okay, so now we know how to respond to that. And him a rejection of his repudiation. Now, for the original trustee that was set up by the bank in a foreclosure, the first thing they do is they appoint a law firm, the trustee, and they send you a notice that a new trustee has been appointed, and he initiates the foreclosure. Now, we sent him an indenture and told him to do his duty, which was to extinguish the debt and send a receipt. And he has failed to do so. Now, isn't he in breach of trust and on the hook, as it were?
Yeah, was this a non-judicial state?
Yes.
Okay, they set up a statutory trust to do this, the foreclosure and sale.
Mhm. Yeah, they call it a trust sale.
Yeah, you have to do an NTT process on that trust.
Right.
Which would be another trust.
Mhm. So that would be a claiming the all rights, titles, and interest to that trust or the suit.
Yeah, get yourself grantor position on that one, beneficiary position, so you can fire that trustee.
Okay.
Point yourself, maybe trustee.
Yeah. Well, that's the one they've denied and ignored all of that trust documents. And proceeded with the sale. They went ahead and did the sale.
Oh, they did the sale?
Yeah.
Okay, so you don't have to worry about going back in there and do anything for that one because the trust already completed and probably terminated with the sale then. But then it was a wrongful conveyance, so.
Yeah, and they had a trust document or a orders from the grantor to settle the matter before they sold it. They ignored that.
Yeah, by operational law, they get you an agreement that you're going to sell the property at a trustee sale.
So now we're still expressing the trust on that. Is that going to create a problem for them?
Yeah, it's going to create a problem for them.
Are they going to have to explain why the trustee didn't do his duty?
Well, according to them, he did his duty. He sold the property. So no, unless you can get some kind of other duty that he was supposed to be doing.
Okay.
That he did a breach of the trust and sold the property and pocketed the money himself. So he commingled the funds.
Uh-huh.
So it's like, but you got to go back to the root. So this is like following maybe a string of trusts, maybe 3 or 4 or 5 trusts involved here. Each one based on the previous trust. So it's like the mortgage you got was a trust when you bought the house. Went into, say, default on the debtor creditor stuff, and then they did a court action to foreclose, which was another trust. Then they, well, if it was non-judicial state, then it would be, say, another trust anyway, but it would be non-judicial.
Mm-hmm.
Then they sold the property, but each one's another trust doing another action. It all comes back down to the first trust is where the root goes into the ground.
Now, that would be the one that we're expressing a trust on or going back and correcting the misconstruement, right?
Yeah, because these other trusts give rise out of that original trust.
Uh-huh. So now they've done all this other stuff like sell the property and all that stuff on top of or outside of another trust. They weren't they not the holder of the note and as trustee, they were the fiduciary of that note, and they kind of sold that note. So now are they in breach of trust on that trust?
Yes, if you can prove it and present it. Claim trusts come in, with that they didn't perform according to what they're supposed to do.
Well, we have a copy of the note where it was signed and conveyed or sold by the assistant vice president of whatever institution who signed it and put another line on.
Maybe the problem that I'm starting to see now where we might have a problem is where they're going to say that the trust never vested, and there's where you'd probably have to strengthen up your arguments.
Uh-huh. So how would you, how might one combat this argument that the trust never vested?
Well, there's where I'd probably do some discovery to point out that they received trust res, or let's not say, I'm going to say it's trust res, let's say that they received something from me on such and such a date, and they didn't, did they not sign the green card, they accepted delivery and blah, blah, blah. Because that way, that was really trust res, and if they got it, then that was the method of formation. And in there contained the declaration, say, and other documentation to express the trust. Now, because what I think they're going to do is they're going to say that the trust never vested, we never got it, or we never got trust res, it wasn't a trust. So if the trust never vested, it was an incomplete trust.
So the indenture came much later than the actual signing of the note and exchange of the note for the property. So are they going to use that as an argument? Well, it never vested, so we did this before you did that?
Yeah, I expect them to choose any kind of argument they can think of, and that would be one that I would be saying that they might counterattack with.
Uh-huh. Okay.
Now, if there was a valid trust and it just didn't vest in the trustee, then that doesn't mean that there is no trust, though, because equity will not allow a trust to fail for a want of a trustee.
Right.
And the Court of Equity will then appoint a trustee to carry out the duties. But then if you appointed a trustee to carry out the duties, trust res is with, say, the bank, and they would have to return a trust res. So that actually the pointing out that that the trust did vest was the fact that they're still holding trust res and they won't give it up.
Right.
But they're obviously acting as trustees, because if they don't want to be trustees, give me the trust res back and we'll just call it even then. But if you can't give me trust res back that was sent to you, then you're obviously acting as a trustee. Then there is a trust and it has vested. Now, why won't you do the performance?
Right.
And that's really the whole argument on the plate. So you don't want to argue the debtor-creditor side, at-law side on this case at all. Or you want to get them to argue the fact that there is a trust, because that's what's got to be proved first.
Well, they received the note, so is that not the evidence that there was a trust?
You have the indenture and you have the elements and the method of formation, and that was trust res. Then if that's everything necessary that the law recognizes to be a trust, then it's trust.
All right. Well, at the time of the sale, at the closing, the trustee, who is the abstract company, takes the note and gives it immediately to the bank. Or that's the way this one was conducted.
Yeah. Well, that's why it's so important to create records or evidence. Because I was looking over a case here. It was Nats versus FDIC. And Nats was an attorney.
Mm-hmm.
And he was doing collections for the bank that he was working for and had a signed contract on behalf of the bank. But the fact that this guy was an attorney and he got into debt with the bank there for services and the bank got into a liquidity problem. It was bankrupt, insolvent, and the FDIC came in and took it over, and he was kind of like stuck out on a limb with about $160,000 worth of fees on collections that he had done for the bank, and they wouldn't pay him for, although they'd set up a track record of payment as in the past. So they had made business dealings with him in the past. So he was giving printouts to the receiver of the bank before the Comptroller of the Currency declared that they were in bankruptcy. And the FDIC stepped in and said, send us a bill and we'll see where we get you paid. And then they dishonored the bill and said, no, we don't owe you. So he had to take and sue them, go into court, this attorney, and commence an action within the time limit frame that FDIC is allowed for his claim. And he went in and I guess he lost that, so they had to go on appeal, and they did a de novo case on appeal. And it was all about contract disputes involving private rights, which are the core of the matter, is normally reserved for an Article III court, it says here. And this was citing another case. That came down to the merits of Natz's claim, which were arising out of the services rendered to the bank, and that he was entitled to recover the full $190,000 claimed. And it was only on evidence proffered by Natz in support of his claim amounted to his computer printout. The court finds that this document was insufficient, reliable to establish by a preponderance of the evidence that Natz entitlement payment of $190,000 under a breach of contract. So Natz, like a typical attorney, relied heavily on treatises and case discussing presumptions of law and fact and other operative effect, although Natz failed to identify a rule of law by which the presumption attaches to his case. And the court then found that Natz did not prove his claim for the full amount of $190,000 and therefore addresses Natz's claim for $165,000 predicated on an account stated. Now we go into the account stated pleading where the FDIC considered that the account stated wasn't properly pled by Natz, and reviewed Natz's amended complaint reveals no mention of account stated as a cause of action. So nevertheless, the court notes that entered into a contractual agreement with Natz, which Natz agreed to provide legal service to the bank on various legal accounts, and he had correct photocopies of the contract, which was attached. And the bank paid legal bills and invoices submitted to Natz from certain dates past and began to pay sporadically, and then they stopped paying bills altogether. And the court found that these allegations sufficient to prove the FDIC with notice of the essence of Natz's claim, namely that he billed the bank for fees but had not been paid. And Natz's claim for account stated was fully addressed at trial. And the court found that the FDIC was not prejudiced by the admission of evidence at the trial in support of the claim and deems the pleadings amended to conform to such evidence. And the thing is to stress the evidence of the records. And hence the court rejects FDIC's argument that Natz failed to plead the elements of a claim for account stated without more precludes his recovery under the cause of the action. So then went into the account stated, the elements of the claim. So there it is, the elements.
Mm-hmm.
And the account stated generally arises from a rendition of statement transactions between a party with failure of a party to pay. And let's see, jumping down through to get to the meat of the thing. Plaintiff may prove a prima facie case for account stated by proffering evidence that the account was rendered under circumstances which raises a presumption of absence. So the plaintiff must show that at the time of the stating of the account, there had been previous dealings and transactions with the defendant. So now to say the account stated proof. So the court found that binds the bank through the apparent signature of some executive there. And it said the letter that was written, together with the contract which ratifies, constitutes evidence of a previous dealings between Nance and the bank. And the letter is also evidence of an agreement between Nance and the bank, which fixes the amount due that Nance in respect of the transaction was $46,000 there. And finally, the letter contains an express promise on the part of the bank to pay this amount, plus additional sums to be accrued pursuant to the agreed telephone reporting system. So here's the point. It was the letter and the contract, two pieces of SOI evidence to support his claim. Now, in the first part, down below here it says, to overcome a prima facie case proved by Nance, the FDIC had to offer proof of fraud, duress, or mistake, and that was to overcome the prima facie case. The party attacking the count stated must offer proof of fraud, duress, mistake, or other grounds. And that's what the FDIC came back at him at because they didn't want to pay the bill. But to overcome, FDIC had to come up with proof. They couldn't come up with proof.
Right.
So his two records that he had substantiated, 2 records or more substantiated his case, and he beat the FDIC based on 2 or more records, 2 SOIs.
Right. So that is an example of how important it is to get your SOIs in.
Yes, the importance of creating records, even though they may be just letters sent back to the bank, say, and pointing them back to the fact that there's a trust here, and why aren't you doing the duty?
Right.
That creates separate records of you not expressing, but authenticating the trust rather than authenticating the debt. Acknowledging the trust instead of acknowledging the debt.
Right. Yeah.
Because it's the greater weight of evidence. Because if the FDIC came up with 2 records, then they'd be off and running. But since they couldn't come up with that, then his 2 records stood.
His records, well, had the greater evidence or the greater weight.
Yeah, so even letters sent back, they're not, because the letters that they're sending you, that's what they're creating. They're creating records, they're creating evidence.
Right.
So the importance of creating records to rebut.
Okay. Now, you were saying that you need to have an evidentiary hearing to enter these records into the case. Do you just file a motion in the case with the court to the judge and then request a date for an evidentiary hearing, or I know one
notice of evidentiary hearing. Go to the JA and get a date.
So you go and get a date for the hearing from the judge's assistant or secretary, whatever.
Yes.
Okay.
Then do a notice of filing of the evidence copies.
So the copies would go into the case and to the opposite side?
Yes, that way there's no surprise. The other party got notice. They received copies. They're aware what's going to be talked about, and they can't explain this is a surprise and do a continuation.
Right. Okay.
And then you put in a motion to admit this into evidence. And then it would be your attachments, and you would bring the originals.
In chambers?
Either a evidentiary hearing, depending what case you got. If you got a statutory one, you're going to do it on the at-law side, or if you've got a private trust, then you're going to do it on in-chambers hearing.
Right. Well, most of these would be the trust, and our SOIs would be the UCCs and the county filings of the notices, would it not be?
Along the lines of the letters and things that you sent back to them to build your case.
Oh, okay. Okay. Well, we're slowly getting there, hopefully.
Slowly, yes.
I guess in a few weeks we'll know how well we've done on our homework. If
you beef up that memorandum and put a little equity in there, expression of the equity, then that'll be presenting the judge with the law to rule on.
Uh-huh. So it would be okay to put the memorandum that I sent you last night, and then put the equitable maxims, and then
make that memorandum two parts. Make one for equity and make one for trust.
Trust. Okay. Okay. Well, I appreciate it. That's really good information.
Okay.
Thanks again.
I'll be sure to Skype so I can give you that one file.
Okay, I'll do that. Appreciate it.
Okay, I guess we've got a couple minutes left. We've got enough for maybe one small short one. Hello, Matt, you there?
Can you hear me?
Yes, now I hear you.
I was flapping my jaw and nobody heard me.
No.
My headset must have
Spots, I guess. So.
must have pulled out just far enough that wasn't connected. I had St. Greta Grotto standing by for a question, and he dropped off. So we don't have any callers right now. We'll put out one last call here, folks. If you got a question for Christian, hit star 8 on your phone. Star 8, folks, and we'll give you an opportunity to ask Christian a question. This is our last call for the night. If anybody's got a quick question for Christian? Somebody did ask a question, Christian. I don't know if you know the answer, regarding judicial and non-judicial states. If there's a list showing which is which. There is.
I don't know this, but there might be one out there.
I've never seen one.
Neither
I heard that there's a book. I don't know what the name of the book is, but it's kind of a compilation of all the states and all the different foreclosure laws in the states. Now, I wonder if that book would have something like that in there.
Quite possibly might, yeah.
I know Minnesota is a state where you can go either way, judicial or non-judicial. Most of the banks here do go non-judicial, though. So, anyways, I'm not seeing any responses out here. Christian. So it looks like we're going to wrap it up for the night.
Okay. All right.
So, folks, thanks so much for joining us, and we'll look forward to having you join us again next Wednesday. If you do have a question between now and then, be sure to write it down so you don't forget, and then hit star 8 as soon as you get an opportunity on our call next Wednesday night at 8 p.m. Eastern Time. Until then, have a great weekend, and we'll talk at you next week. Thanks, Christian.
Okay. Thank you, Matt.
Always a pleasure. Have a great evening.
Thank you.
All right. Night, everybody.